Good afternoon to one and all present here. On behalf of Center for Criminology, Criminal Justice and Forensic Science, I extend a very warm welcome to everyone gathered for today's special lecture. We are truly honored to host an eminent personality from the field of criminal law and financial crime investigation, Sri Mayank Makhija sir. We are privileged to have among us respected registrar sir, respected center head Dr. IFT Thaide. Your presence adds immense value to this occasion and we thank you for joining us. We are delighted to share that Live Law is our official media partner for today's event. We deeply appreciate their support in bringing our initiative to a wider audience. I now request Registrar Sir to kindly come forward and felicitate our esteemed guest with a sapling, a shriefal, shawl and memento as a token of respect and warm welcome. Advocate Mayank Makhija sir brings with him over 13 years of rich experience in criminal law, financial crimes, and prosecution strategy. He began his career as a law officer with Canara Banks and later as assistant public prosecutor with the CBI. He led prosecutions in some of India's most sensitive and high-profile cases of national importance. His portfolio includes landmark matters such as NRHM scam, PF scam, Dabholkar murder case, proceedings involving V. Senthil Balaji, Satinder Antil, Nirav Modi, Vijay Mallya, and Yadav Singh, among others. His work often required intricate financial analysis, cross-border evidence gathering, and strategic courtroom advocacy. He is an alumnus of University of Delhi with a master's degree from Ajinkya D.Y. Patil University and a PG diploma in human rights. He is also UGC NET qualified. His special training in prosecution techniques and financial crime investigation perfectly complements his academic foundation. Recognized for his meticulous legal acumen and practical insights, he continues to contribute significantly to India's fight against economic offenses. So I encourage all of you, as you listen to him today, to note down your queries, thoughts, and curiosities and make the most of the opportunity. So, we are eagerly looking forward to hearing your experiences, insights, and guidance. And now invite you to kindly deliver your lecture.
Before starting my lecture, I would like to say that I'm very happy to see young people who are attending my session because usually I am training prosecutors, police officers, IRS, IAS. Seldom do I get an opportunity to have a word with budding lawyers. So I am very happy to see fresh faces from in some time you will also be entering the field, and certainly I hope that whatever I share here with you people will help you a lot, because when we were on the other side we used to also look up to people to mentor us. So today when we will be discussing, I will not only give you a hold about PMLA but white collar crime in general also. So you will get to know what white collar crime is and how we are prosecuting the same, and what are the strategies for the same. In this present day's time, whosoever is reading a newspaper will get to see ED either on the front page or in many of the pages. We are regularly hitting headlines because we are handling the few of the most sensitive cases across the country. So the first thing which we need to understand as to how PMLA works. What is PMLA? PMLA is a legislation to curb money laundering. So, what are the objectives of PMLA? Whenever we want to understand a statute, we should first see what is the objective of the statute and why the statute came into being. So, the purpose of PMLA is twofold. Firstly, to prevent money laundering, and secondly, to confiscate proceeds of crime. These are the twofold objectives of PMLA. There are certain legislation that cater only and only to domestic needs of a country, like rent control law, like transfer of property, like contract act. These are largely confined to the country itself and having little international effect. But PML is one such legislation which has impact across the globe. And it was passed in India because of UN resolutions. UN resolution against convention against illicit trafficking in narcotic drugs and trafficking, and to prevent transnational organized crime. This is the basis because of which India had to pass a money laundering law. And this is the reason why money laundering law is very significant for the country. If we don't have a effective money laundering law in our country, we won't be able to borrow money from World Bank, from IMF, or from other international funds. Because if you are having a bad rating in money laundering regime, then the country gets barred from taking loans from outside. So it will directly hit our infrastructure. And some of the countries will not allow our country to trade with them. Our trade will also be hit. So this is the reason why money laundering is so important for the country. Like all of you have heard about UN. Have you heard about FATF? This is an intergovernment agency that looks after the money laundering principles and it gives peer review. India had recently gone through FATF review and we had got a satisfactory rating. Unless and until we are getting a satisfactory rating in FATF, our country will not be in a position to take economic funds from other international forums. So now, one part of the perspective you have gotten that why money laundering is so important. The first thing, why money laundering is so important, you have got that point. Secondly, you have got that why we brought this legislation because of the international conventions. Now we will come to the legislation. What the legislation is in fact and how it works. So the landmark judgment as on date in our country on money laundering law is Vijay Madan Lal Chaudhary. In that case, the Supreme Court elucidated that there are certain foundational facts that are required to be established by the Enforcement Directorate for establishing the offense of money laundering. These are threefold foundational facts. First is commission of an activity relating to scheduled offense. Then generation of proceeds of crime therefrom. Then there has to be a process or activity of money laundering with respect to those proceeds of crime. In this very judgment, Vijay Madan Lal Chaudhary, Supreme Court stated that PMLA is a sui generis law. If you have gone through Vijay Madan Lal Chaudhary, you would be knowing that PMLA is a sui generis law. Sui generis means of its own kind. Why the court was compelled to give such a statement that PMLA is a sui generis law? Because in that petition, defense had challenged the constitutional validity of most of the provisions of PMLA. And the basic premise on which the constitutional validity was challenged was PMLA lacks the safeguards that are there in CRPC. There are certain restrictions which are there on police powers in CRPC which are not there in PMLA. So this was the premise on the basis of which the defense had challenged the constitutional validity of PMLA provisions. So court delineated how PMLA is an exception to the CRPC, how it follows a different scheme. PMLA is a self-contained code on money laundering law. PMLA is a self-contained code and it is a complete law in itself, though it provides for application of CRPC in restricted sense. The important provisions is the section 71. 71 of PMLA gives a non-obstante clause, which says that PMLA will override other laws. And 65 says wherever PMLA is silent, CRPC will apply. So where CRPC is PMLA is silent, we take recourse to PMLA, but where provisions are contained in PMLA itself, we follow the PMLA scheme. Now, why the Honorable Apex Court made this observation that PML is a sui generis law was because normally if you look at the scheme of CRPC, police only has criminal side powers. They don't have any civil powers. But in PMLA, ED has both the powers, civil as well as criminal. We issue a provisional attachment order. That is the power on the civil side, and we file a prosecution complaint. That is on the criminal side, and we have adjudicatory forums on both the sides. For civil, they are separate. For criminal, they are separate. So, what is the pivot around which the PMLA revolves? Every statute is brought to curb one mischief. The entire PMLA revolves around the concept of proceeds of crime. What is the purpose of bringing PMLA? That the accused or the criminal should not be allowed to reap the benefits of the crime. Whatever financial gain the accused or the person concerned has derived or obtained by committing a crime should be taken away from him, so that the motivation to commit a crime goes away. It strikes at the very root that the motivation for a criminal to commit the crime goes away, that the money which he gets from it should be taken away. And in PMLA, like I was telling you, the only agency that is authorized in India to work around PMLA is Enforcement Directorate. No other agency in India can work in PMLA other than Enforcement Directorate. There are special statutory provisions regarding arrest, search, seizure, filing of prosecution complaint, bail, and these provisions I will be discussing with you in detail in this session. So firstly, I will start with the civil aspect. So I have already told you that ED has both the powers, civil as well criminal. On the civil side, when ED gets the information that some crime has been committed which is a scheduled offense, ED cannot investigate any offense. ED can investigate only a scheduled offense. There are 3 schedules in the PMLA. Schedule A, Schedule B, Schedule C. Only if one of the scheduled offense has happened can ED come into the picture. We get numerous complaints from numerous people. But unless first we have a prima facie look at the complaint, and only if we are able to ascertain happening of a scheduled offense, then only the jurisdiction of ED comes into the picture. Sometimes it may so happen that the scheduled offense has not been registered, but we get to know that the scheduled offense has happened. So we can use our civil powers and intimate the other agency that when the scheduled offense has happened, you also take action. So what do we do? When we get to know that a scheduled offense has happened and proceeds of crime has been generated therefrom, the first thing we will do is to attach those proceeds of crime. Those are classified into 2. Either we will attach the direct proceeds of crime, or if the direct proceeds of crime have been dissipated or they are not available for attachment, then we will attach the equivalent value or value thereof. This is called equivalent value or value thereof attachment. Supposedly X had earned rupees 1 crore from extortion. And when ED apprehended him and arrested him, and during his interrogation, he was asked where that 1 crore has gone. He said that I had dues and I have cleared the dues with those 1 crores. So 1 crore I am not having right now. Now he didn't purchase any property therefrom. So we cannot attach those 1 crore. So what will we do? We will attach any other property of the concerned person worth the value of rupees 1 crore. This is a distinguishing feature. Why PMLA is so important is because of this. Earlier, what used to happen that the investigating agencies, in cases of bank fraud or in cases of financial fraud, what happened? The FIR was registered after successful collection of evidence. Prosecution was launched. Accused was found guilty and sent behind the bars. But the money did not return to the system. The money was siphoned off. Police or CBI or other agencies don't focus on the recovery part. They are only concerned with the prosecution, successful prosecution of the economic offender, not with finding the money trail. So that money trail element was missing. This part, money trail part, ED is doing. We are complementing the financial system of the country. Supposedly, bank is lending money to the lenders and the loan is becoming NPA. Some of the funds their bank is able to recover by using SARFAESI or Insolvency and Bankruptcy Act. But there are funds that are hidden by the concerned person. Those funds ED is able to trace up. Are you getting my point? So, for the financial health of the country, ED is one of the pillars. Because the money that is being taken away by doing white collar offense, which are very meticulously planned, and the agencies are not able to grab hold of the money which the taxpayers have lost, are being recovered through money laundering laws. Recently, we have restituted thousands of crores in many cases. Like you would have seen home buyer scam, like builders are launching schemes, people are investing their hard-earned money and the builder is committing scam and they are not delivering the flats. They are cheating the buyers. Or bank is lending money and the money is being siphoned off for some other purpose. These are some of the examples. In those cases, where did the money go and how it has to be brought back? That is for ED to see. So to attach the assets, we issue a provisional attachment order. The validity of a provisional attachment order is 180 days. During that 180 days, after the passing of a PEO, we file a OC, original complaint, before the adjudicating authority. This is the administrative authority on the civil side, which acts as a check and balance on the civil side's power of the ED. So if that authority, after issuing show cause to the concerned noticee or accused, is satisfied that the money which has been attached or the assets which has been attached by the ED is proceeds of crime, it will confirm the attachment of ED. Then that attachment will continue for 365 days. If the prosecution complaint is filed within 365 days, the attachment will continue during the entire trial. This is the mechanism on the civil side. For passing a provisional attachment order, an officer of the rank of deputy director is competent to pass a provisional attachment order. But for passing a provisional attachment order, he should have material in his possession on the basis of which the officer will record reasons to believe that so and so property which we are attaching is either direct proceeds of crime or proceeds of crime has been dissipated and we are attaching equivalent value property. After recording, we pass a PO and that PO is confirmed by the adjudicating authority. If ED or the opposite party is aggrieved by the order of adjudicating authority, then we have an appellate forum called appellate tribunal. The appeal from the orders of adjudicating authority goes to the forum of appellate tribunal. If we are aggrieved by the order of appellate tribunal, we then can move the high court. And if we are not satisfied with the high court order also, then we go to the honorable apex court. This is the hierarchy on the civil side. On the criminal side, we are filing prosecution complaint before the special court that is notified under PMLA. The concerned court is of a court of session rank and we are having a court of session trial only in our PMLA cases. So there are certain process or activities of money laundering. What does the term money laundering mean? The biggest myth, the biggest myth, I will bust it in this session, that people have about money laundering. And this I am talking about the lawyer community also. Many lawyers also think that converting black money into white money is money laundering. No. Black into white is the jurisdiction of income tax authority. ED is not meant to check कि किसी ने black money को white money में convert किया. We are not for that purpose. Many times we get a complaint. जिसमें the complainant says कि he has bought a property and he was not having the wherewithal for buying that property. So it is black money. So ED should investigate. ED is not meant to investigate black money. We are not for that. That is the prerogative of the income tax authority. We come into picture only when money is generated from scheduled offense. Unless and until money is generated from scheduled offense, we cannot come into the picture. So this is the basic fundamental of PMLA. Am I clear? After this session, none of you should hold a myth that ED investigates black money. Because most of the people, even when I am conducting interview for ED post, I ask what is money laundering. The candidate says converting of black money into white money is money laundering. That is the most absurd thing. Okay, as a legal personnel, you should know what is PMLA and what is our jurisdiction. Our jurisdiction kicks in only when scheduled offense happens. And ED's predicate offense, we call it scheduled offense as well as predicate case. ED's scheduled offense or predicate case need not be confined to India's jurisdiction only. We have jurisdiction to investigate cross-border offenses also. There is a section 2(1)(RA. In that, there are offenses of cross-border implications. And in the beginning of the session, I told you there are 3 schedules. Schedule A, Schedule B, Schedule 3C. Schedule C deals with offense of cross-border implication. So if the predicate is happened in US or some other country, and they send us information that so and so an offense has happened, and the money, some part of that crime money has come to India, we can investigate that money laundering thing in India also. We can give assistance to that country also if they seek from us in identifying the assets or in identifying the accused or in locating the property or in getting the witness statement recorded. And if they are not investigating the money laundering aspect, they are only investigating the predicate offense in that country. And the money has come to India. So we can investigate money laundering in India based on the predicate case of foreign agency. So the counters of or the jurisdiction of ED is not confined only to Indian agencies. It need not be that the predicate case has been registered by some investigating agencies of India only. It can be of abroad agencies also. Are we clear? There is a clear-cut chapter in PMLA about international cooperation. Like we have having in CRPC, we are having an international chapter in PMLA also, regarding evidence collection and assistance from court there from foreign countries, and also reciprocal arrangements with Indian authorities for the foreign people. Now, the question is what are the process or activities of money laundering and whether money laundering is a strict liability offense. I hope you people know what is a strict liability offense, which does not require mens rea. But for committing PMLA, mens rea is required. If you see section 3, the word knowledge is used. What is knowledge? It is the mens rea. Knowingly assist, knowingly the party is actually involved. And what are the process or activities? Conceal, acquire, use, possess, claim, project. These are the 6 activities. Whoever knowingly assists, who is knowingly is actually involved, is actually the party to conceal, acquire, use, possess, claim, project vis-a-vis the proceeds of crime has committed money laundering. Am I clear? Even attempting of these activities falls foul of section 3. The offense of money laundering is contained in section 3 of PMLA, and the punishment part is provided in section 4. And if the offense is committed by a juridical person, not by a natural person, then we invoke section 70. if the offense is committed by a company or a juridical person, then to prosecute the company or the juridical person, we invoke section 70. But the process or activity remains the same of section 3. So if the process or activities of money laundering, which I have explained, these 6 activities happen vis-a-vis the proceeds of crime, we say that the money laundering offense has happened. Like police registers a FIR, we register a ECIR. The difference between FIR and ECIR is that FIR is a public document. ECIR is not a public document. We don't supply copy of ECIR to accused. Are we clear? So how do we investigate money laundering? What are the tools? The tools are search, seizure, survey, arrest. But the difference is we don't go to the court of law seeking arrest warrant or search warrant. Like the local police or the CBI are investigated, they go to the court seeking search warrant, arrest warrant. ED, the officers within the ED of the rank of deputy director are empowered to issue search warrant or arrest warrant. So this is the difference. And secondly, the difference is that police can arrest on the basis of suspicion also. But for arresting by a ED official, we require the same conditions that we require for issuing a PO. That reasons to believe have to be recorded on the basis of material in possession that the concerned person is guilty of the offense of money laundering. Unless and until we have the material in possession on the basis of which reasons to believe can be recorded that so and so person has committed the offense of money laundering, we cannot exercise the power of arrest. Are we clear? Like police take police custody, we take ED custody. The limits are the same. Police custody is also of 15 days, ED custody is also of 15 days. But the procedure varies. Our arrest and law has been settled on that, but the arrest cannot be done only for the purposes of investigation. That is settled. And there are certain special presumptions also in PMLA. Like we were discussing the authorities, that there are special authorities like adjudicating authorities, there appellate tribunal is there, special court is there. What makes PMLA unique? There are certain facets which makes it different from ordinary criminal law. Why? Because in the beginning I told you that PMLA has twofold objective: prevention of money laundering and confiscation of proceeds of, because it is a preventive legislation also. Ordinarily, if we see, then the stages of criminal offense, criminal investigation are classified into 3: investigation, inquiry, trial. But in ED, investigation and inquiry is done parallelly by the ED. Inquiry by the court is a separate thing, and ED also has the power to do inquiry. When we are exercising our civil powers, we are doing inquiry also. And one thing, ED officers are not police officers. So we are doing inquiry, and there is a certain difference when we are calling the person and we are summoning the person, and when the police is summoning the person. When police is summoning the person, they have different mechanism. For witness, they have 6 separate section. For calling and for accused, they have 6 different section. But when we are conducting an inquiry, we are sending section 15 notice. Section 15 notice. And the evidence that is recorded under 50 is judicially admissible. If you see the police statement which is recorded under 161, that can be used only for the purpose of contradiction. Police statement can be used only for the purpose of contradiction. But our statement, ED statement, which is recorded under 50, is a admissible piece of evidence. And the concerned person is bound to state the truth. Otherwise, criminal complaint can be lodged against him under section 63 of PMLA. And if he fails to appear, then proceeding can be taken against him within PMLA as well as under 174 IPC. So there are certain things which are different from the ordinary criminal law. Firstly, this being the statement. Secondly, the statement recorded by the police officer, the concerned person has the protection of Article 20, Clause 3 as well as Section 25 Evidence Act. But if the statement is recorded under Section 50, the concerned person does not have the protection of Article 20, Clause 3 self-incrimination or 25 Evidence Act unless and until the person was in custody. If the person was in custody when his statement was being taken, then custody of ED or custody of LEA. If he is in custody, then the statement will be hit by Article 20, Clause 3 or Section 25 of Evidence Act. Otherwise, his statement will be admissible. The confessional portion then cannot be used against him if he is in custody. This was recently declared by Honorable Supreme Court in the judgment of Prem Prakash. Now, after a series of judgment, we have been directed by the Honorable Courts to also supply grounds of arrest to the accused at the time of arrest in writing. And further, I told you beforehand that we are recording reasons to believe when we are arresting. So those reasons to believe are also to be supplied to the accused now, after the judgment of Arvind Kejriwal and Manish Sisodia. So we have to supply the grounds of arrest in writing also, and we have to give the reasons to believe also. Are we clear? So there are certain special presumptions in ED cases under 22 to 24. If the accused is coming and surrendering some documents to ED, or we are getting some documents during our search and seizure, then the contents of those documents or the authorship of those documents, the court shall presume that the contents are correct and the author is that person by whom it is purported to be signed or written. These presumptions are not available in Evidence Act or does not apply in ordinary criminal cases. Then there is a concept of interconnected transaction. If, say, there are 100 transactions with respect to POC and ED is able to establish a single transaction, then with respect to the remaining transaction, the court will presume that this is a proceeds of crime transaction. We need not prove all the transaction. By proving one transaction, and there is a chain through which the transaction is going. By proving one transaction, the chain will be proved. Then there is a concept of reverse burden of proof, which we are having in very less number of laws, and PMLA is one of them. In the beginning of the session, I told you that there are certain foundational facts in a ED case. There is a commission of activity relating to scheduled offense, there is a generation of POC, and there is a processor activity. When ED is able to establish the foundational facts in a case, then the burden of proof, onus of proof shifts upon the accused to prove his innocence. If he has been charged by the court, then it is a shall presume burden, and if he has not been charged, before that it is a may presume judgment, may presume onus. This is called the reverse burden of proof. We are having special courts for trying our offences. Then, to protect the sanctity of money laundering cases, we are having a provision of committal of cases. Suppose there will be almost two agencies. One will be the scheduled offense or predicate agency case, and one will be our case. So, our case, the trial will go on in the special court. So, if we want, so we file an application in the court trying the LEA offense that you transfer or commit this case to our court, so that there is a harmony between the trial of both the offenses. Because if the predicate offense is not decided and our case has ripened before the court, it will lead to anomaly. So to prevent that anomalous situation, we file an application to get those cases of LEA transferred to our court by filing a committal application. In PMLA cases, there are twin conditions regarding grant of bail also. Firstly, the public prosecutor has to be heard. Secondly, the court has to record a positive finding that the accused is not guilty of the offense of money laundering. And if enlarged on bail, he will not commit any other offense. Apart from the tripod test, which is applicable to a normal bail. Those conditions are also applicable to PMLA case. Apart from this, these twin conditions are applicable. That public prosecutor has to be heard and the court has to record a finding that accused has not committed the offense of money laundering, and if enlarged on bail, he will not commit any further offense. So because of these twin conditions, it becomes difficult to get a bail in PMLA cases. Now, these are the various sections which I have discussed with you. Till now, if you are having any doubt, you can note it down. When we will conclude the session, we will discuss about it. When we began the session, I discussed that the pivoting point or the mischief which is to be curbed by introducing PMLA is proceeds of crime. So what is proceeds of crime? What is proceeds of crime? Any property derived or obtained from commission of scheduled offense. It can be movable, it can be immovable, it can be tangible, it can be intangible, it can be corporeal, it can be incorporeal. The definition of proceeds of crime is very vast. And we cannot only attach the property in India, but in foreign jurisdictions also, like we did in the Nirav Modi case. Ordinarily, if you talk about money laundering and ask people that what is money laundering, they say placement, layering, integration. That is the basic definition, which you will find on Google also. If you Google what are the activities of money laundering, it will say placement, layering, integration. But if you study the law, it is not about placement, layering, integration. It is the process or activities which we have discussed in this session. And there can be situations in which a scheduled offense may have happened, but proceeds may not have been generated therefrom. It is not the absolute mandate of law that if a scheduled offense has happened, proceeds of crime would have been generated therefrom. That is not necessary. Supposedly, a person A kills B. Now, if A had taken a contract to kill B, then he would have generated proceeds of crime. But if in a fit of rage, or if supposedly there is a case of honor killing, so where are the proceeds of crime in that case? So it need not so happen that if a scheduled offense has happened, so there will be proceeds of crime. No. There may be cases where scheduled offense may have happened, but proceeds of crime are not there. And if proceeds of crime are not there, ED's jurisdiction will not be there. Are we clear on this? Commission of activity relating to scheduled offense is a sine qua non for instituting the jurisdiction of Enforcement Directorate. Now, there are various mechanisms by which money laundering is committed. One of them, the most prevalent one, is incorporation of shell companies. Some are like transfer through trusts, international trusts. In some of the cases, we have seen that there are certain tax haven countries and trusts are being created in those countries, and property is being settled in favor of the trust, so as to complicate the ownership. If the agency wants to understand to whom the property belongs, it becomes very difficult. This is the layering part, wherein the property gets layered. So opening of shell companies, transaction done through trust, using tax haven countries, these are the mechanisms which are being used by the criminals to obfuscate the origin of the proceeds of crime. Are we clear till now? In many cases which I have rendered legal advice in, what we are saying is that novel methods are being used. Like you would be saying this days, there is a lot of rise in cybercrime. And you will be seeing that there are mule accounts. Rickshaw pullers or poor people who are not aware, they are given some money and their account details are taken and money is transferred in those accounts. And when we apprehend them, they say we have no knowledge as to you who has used our accounts. So the offense of investigating offense of money laundering is a Herculean task because it is not confined to our country. The jurisdiction in which the money would have gone can be anywhere. It can be in any country. Recently, you will have seen newspaper reports that crores of rupees were changed hand within minutes, and through those accounts in which there was no transactions. So, investigating a money laundering offense is a daunting task. And the timeline for concluding the investigation ideally is 60 days because the PMLA offense is punishable by 7 years. So if we don't conclude that investigation in 60 days, there is a prospect of the accused getting the default bail. And it is highly improbable that we will be able to conclude an investigation in 60 days time. Now, how does the ED's jurisdiction, if we see the police or the CBI, they are getting the complaints from the complainant. But how the ED is doing the cases? We are getting information from other LEAs. There are two special provisions in PMLA, 54 and 66. In 54, we seek information, and in 66, we share the information. If supposedly ED is investigating an offense and we get to know that there is some incriminating material which the LE or the predicate agency will not be having, then we share that information with the other agency under section 66. And if we require assistance from other agencies, we send a letter under 54 seeking information. We don't have direct complainants. In a police or in CBI case, you will find direct complainants. CBI mostly you will see that the banker is giving the complaint, or the person from whom bribe is sought is approaching the CBI, or in the local police, the victim will go to the police and say that so and so person has beaten me, or so and so has taken away my property, or so and so has stolen my thing. So a complainant is ascertainable. But in our cases, complainant might not be ascertainable. This is one of the difference in our case and in other LES cases. And the mechanism for starting our case is either there can be a FIR in the LEA case on the basis of which ED can start its investigation, or there can be a criminal case lodged, criminal complaint lodged under 200 CRPC. Sometimes what happens that the statute of an agency is violated and we get the information, but the criminal complaint mechanism is not lodged under that act. There are certain acts in which prosecution is launched only when a criminal complaint is filed by the public servant concerned under that act by filing a criminal complaint under 200 CRPC. So unless and until a criminal complaint is filed and cognizance has been taken thereon, the ED jurisdiction cannot be invoked, though the Agencies Act has been violated. Numerous times we have to send back the complaint saying that criminal procedure has not yet been started. Though your statute might have been violated and you would have received complaint, but criminal complaint has not been filed. And there are certain cases in which it may so happen that the predicate case has still not been registered, but ED gets the information that so and so crime has been committed, and in that proceeds of crime have generated. So in those cases, what we do, we take action on the civil side. We issue our provisional attachment order, and we file the complaint before the adjudicating authority, and we share the information with LEA under 66(2). Now, if the LEA is not taking recourse, not taking action on our complaint, then we take either the CRPC remedy or the writ remedy. Either we will file a letter to the Superintendent of Police under 154(3), if it is the LEA is the police, or we will file an application under 156(3), or we will institute a complaint case under 200 CRPC, or if the LEA is not police, it is some other agency on which CRPC is not applicable, then we will take the writ jurisdiction route. Because ED cannot take action on the criminal side, we cannot file a criminal case, criminal complaint, prosecution complaint, unless and until a predicate case is in existence. Are we clear? So the root, if you understand the fundamental of PMLA, the fundamental is that money has to be generated from a scheduled offense. And only when the money is generated, the jurisdiction of ED gets taken. Unless money is generated from the happening of a scheduled activity, ED cannot come into the picture. Now, a question comes about valuation. Sometimes the state police or the other agency says that the offense has happened of 2 crores and ED says no, it is not 2 crores, it is 20 crores. So the court asks how the LEA is saying 2 crores, you are saying 20 crores. In that case, the ED's quantification or valuation of proceed of crime can vary because the LEA will be only looking at the money that has come from the scheduled offense. But in the beginning, I had told you when a criminal activity relating to scheduled offense has happened, then the ED's jurisdiction comes into the picture. So the word criminal activity relating to scheduled offense is of a much broader connotation than just a scheduled offense. Supposedly, LES investigating a disproportionate assets case. I hope you know a disproportionate assets case. I will give you a brief example. If there is a public servant concerned and over a period of time he has had 20 years of service, LEA takes a check period of 5 years of his service. In that period, he had an income of 1 crore and he had an expenditure of 50 lakhs. And prior to that check period, he had assets of 1 crore. So during the check period, he earned 1 crore and he spent 50 lakhs. So he's having 50 lakhs remaining with him. And prior to the check period, he had assets of 1 crore. Now, after the check period, he has assets of 5 crores. Whereas logically or legally, he should have assets of 1.5 CR. So where did that 3.5 CR came from? That onus is on the public servant concerned to explain. So that this is a case of a disproportionate asset. That the public servant has assets beyond the known sources of his income. Now, LEF prosecute files a charge sheet saying that the DA amount or the disproportionate asset amount is 3.5 crore. And ED says no, it is not 3.5 crore, it is 8 crores. It is legitimate. ED can legitimately say so. If we are able to justify that yes, the disproportionate assets are of 8 crore because we are doing an independent investigation. It may so have happened that he might have invested those 3.5 crores and earned money from that. When I was discussing with you the definition of proceeds of crime, I told you property derived or obtained from commission of scheduled offense. So there is a difference between derive and there is a difference between obtain. In obtain, there are active efforts on the part of the accused. In derive, he may not have done active efforts, but he is getting money therefore. So LEA said that 355 crores on the basis of their investigative. But if we find during our investigation that yes, money which he had gotten from disproportionate assets was invested by him, and he reaped benefit out of that. That benefit part also is proceeds of crime. Are we clear? If a person takes 5,000 rupees bribe and he deposits it in the bank, the interest also which accrues upon that 5,000 is proceeds of crime. Proceeds of crime is not restricted to the initial amount. The figure can vary, and the figure can vary between the LEA as well as ED, but ED has to justify it, how the difference is coming. Because our investigation is a independent investigation. For starting the investigation, we needed a predicate offense. But after we started our investigation, we are an independent agency and our trial is also independent. In the beginning, I told you that we file a committal application to bring the LEA case to our court. But the orders passed in LEA case are not binding on us. Neither the trial conducted in the LEA case is a joint trial with our case. That trial will remain separate. Our trial will remain separate. The only thing is that the court will be same. Just to avoid conflicting orders. And to have a time schedule within which both the trials can conclude. But the orders passed in that case will not be binding upon us. And neither it is necessary that the accused in LEA case should be mandatorily accused in our case, and vice versa. Supposedly A, B, C went to the house of D to steal something, and they stole a precious jewelry. After stealing that jewelry, C gave that jewelry to F. Now F did not go to commit the theft. F did not go to commit the theft. F is only in possession of proceeds of crime. So F cannot be proceeded in the predicate case because he was not part of the things when the theft was planned or committed. So usually the accused takes a plea in ED case that I am not accused in the predicate case. So I should be let scot free. But that is not the case. He may have played a different role. And similarly, it is not necessary that whosoever is accused in the LEA case should be an accused in our case also. Because A, B, C went to commit the theft, but C gave the property to F. A and B did not play any part in giving the property or parting the property. So A and B might not be accused in our case. The accused can be different. Similarly, witnesses can also be different in ED case and in LEA case. And it may so happen that the accused of LEA case is a witness in ED case and reverse also. Most of the time when you see from the defense side, you will be seeing that the accused is taking a plea that I am not involved in the predicate of it. So I cannot commit money laundering. But that is a very lame plea. And there are numerous judgments to that effect. That you need not be an accused in predicate case for becoming a money laundering accused, and vice versa. Many times we cite witness of LEA case as accused in our case, and our witness are accused in their case. So this can happen. What is the evidentiary value of section 50 statement? What is the evidentiary value of 50 statement? It is more than a 161 statement and less than a 164 statement. 161 is recorded by a police officer, 164 is recorded by a magistrate. It is not more than 164, but it is greater than 161. But because 161 is not an admissible piece of evidence, it is only used for the contradiction of the witness. But our 50 statement is admissible. So now we were also discussing about that international cooperation part when we were discussing the Schedule C. So why PML is so important? The purpose of PML being so important is that it does not have ramification only for India. It has international ramification because the proceeds of crime does not only hamper India, they are hampering across the world. And why PMLA was brought into the picture? To curb terror financing. That was one of the objectives. One of the objectives of PMLA is to curb terror financing. And terror financing is not restricted to our country. So PMLA is the backbone of our economic system. One of the backbone of our economic system. Though the legislation only comprises of section 75 section, it is not a voluminous legislation like some of the legislation, but it is certainly one of the most important legislations. Now we can begin with question and answers if you are having question and answer, because we have discussed the entire scheme of PMLA, how the civil aspects work, how the criminal aspect works, what are the presumptions, and if required, we can discuss upon the prosecution complaint also. Like we were discussing that criminal complaint is filed under 200 CRPC. We are filing prosecution complaint under section 44 read with 45 of PMLA. And in ordinary cases, there is a committal. The complaint is filed before a magistrate and it is committed to the session court if it is trial by court of session. In this case, our special court has the jurisdiction to take direct cognizance. We don't follow the committal provision. And for taking the remand also, we produce the accused normally before our special courts only. Now, one important topic which I would like to discuss is the jurisdiction element. How jurisdiction is decided in a PMLA case. Ordinarily, the scheme of thing in the CRPC for jurisdiction is contained in section 177 to 189. But for PMLA, the jurisdiction varies. There are two landmark judgments for that, KA Rauf Sharif and Rana Ayub, that are specifically on the jurisdiction of ED. Wherever any of the process or activity of money laundering, conceal, acquire, use, possess, claim, project happens, any activity, one instance, the jurisdiction of ED will be created for the purposes of court. Ordinarily, in the criminal law, the jurisdiction is created where the offense happens. Wherever the offense happens, the court has the jurisdiction. In whosoever court's jurisdiction the offense happens. But for ED, the jurisdiction varies depending upon the process or activity where it is happening. And it can be pan-India jurisdiction also. We are not restricted to a particular state because usually the money which is flowing in money laundering cases is flowing across borders. It is not restricted to any particular state and in sometimes countries. So for jurisdiction also ED law varies from LES case. By and large, we have discussed all the essential elements of a PMLA case. We can brush it up again. The property, the proceeds of crime, the section 3 process and activities, the adjudicatory forums, the presumptions, and twin conditions, filing of prosecution complaint, difference between civil and criminal powers of ED, the reverse burden of proof, admissibility of section 50 statement, how we prosecute a company, what section we invoke, what are the process or activities, how we take custody, what are the limitations, what are the special conditions for grant of bail. We have covered the PMLA in the entirety, starting from the root, which are the fundamental factors. Three fundamental things which AD has to prove, which we call the foundational facts in a PMLA case. Now I leave the forum open for discussion.
Good afternoon, sir. I had certain questions regarding what you said. So, my first question is with respect to section 3, where you and also that the PML involves the three stages, that there has to be a commission and there has to be the proceeds of crime, and after that, the process related to proceeds of crime. So, my question is that whether the certain activities that has been listed in section 3, the possession, concealment, whether the activities are only those or it can also be the inclusive definition.
Those are restricted to those six activities only.
But sir, in the
Apart from those six activities, only generation of proceeds of crime we treat as a crime. Other than that, the definition six activities we are restricted to that only. Though it is not required that all the activities are committed. Even if a single activity is done, the offense is made off or attempted. Any of the activities are attempted.
but sir, one more foreign question is that in case of the Vijayawada ruling, the court stated that the word include that has been added before the possession concealment, it does not mean limited to there only. It can include the further activities. So what type
But till date, we are restricting our prosecution complaint to those activities only. We have not gone beyond that. Though those activities are interchangeable. When we are filing a prosecution complaint, we have to explain role of each and every accused separately. And it might so happen one has done one activity, the other has done other activity, or all of them have done the same activity. But one activity should have been done or attempted by them to be enrolled as an accused. The activities are not cumulative, not conjunctive. They are in the alternatives. Any act, if one of them process or activity is done or generation there is assistance, we file a prosecution complaint. We have not gone beyond those six activities, practically.
and sir, further my doubt is related to the joint trial. You said that there is mostly in cases there is a committal of the case.
Yes.
And to prevent any kind of decision, alternative decision taken by the session court and the special court. But even in case there is a committal, there is a provision that it will not be treated as a joint trial.
Yes.
So even after there is a committal, they will both be treated separately. So what is the actual objective behind the heading of the committal? Because the result will be altogether the same, that they are not treated as a joint trial.
It is for practical convenience. There are cases in which the PMLA case reaches the fag end. The judge is about to pronounce a judgment. The final arguments have been heard. And in LES case, not even a single witness has been examined. So to avoid that sort of situation, practically we are seeing that cases in which our cases have ripened and are at the stage of judgment, and the LE case has not even started at the stage of prosecution evidence. It is at the stage of charge. So to show that we can have an effective monitoring in those cases also, and we can coordinate with that state agency also, and our cases are running in tandem. Because if that case is not decided, after hearing final argument, the court will have to keep the file in the records only. The judgment cannot be pronounced without there being a judgment in the predicate case. So only for the practical convenience, we get that case committed. coming to our court. Otherwise, we don't have any legal say in that case. We cannot argue in those cases, or we cannot summon the witness. That is for that concerned agency only to look after their cases.
Sir, and last, my doubt is that there's a situation, supposedly, that there's a person A and he gives certain amount of money to person B, and he is suppose a certain officer. So there is some liability upon the person A that he has to file certain returns or something, and he has not filed. Now there is a liability or the penalty imposed by that particular authority officer. Now they reach to an agreement that let's do a settlement. You pay a particular amount to me, we will settle out the matter. So now the person A pays certain amount of money to this authority person. So whether the ED officers or whether this person A and the authority officer will both be prosecuted under the PML or not?
That depends upon what the offense they are being charged with. Because bribe giving is also an offense and bribe taking is also an offense. Depends upon what the LEA case is being of. Supposedly, if the person before gives the bribe contacts LEA and says that so and so officer is demanding money to settle the case, then only the concerned public servant will be involved in the PMLA proceeding. But in case there is a reverse trap, supposedly the bribe giver and the bribe giver both are trapped simultaneously by the LEA, then both will become accused in PMLA case. It depends upon the factual situation, what happens to what transpire in the LEA case. It cannot be a straight-jacket formula for the same. It will vary, and sometimes it so happens that to prove a case, we have to get one of the accused tender pardon because we need evidence before the court of law. If all the person become accused, who will prove the case? So even if both are charged, it may so happen that the person who is having less role, we might try to get him become a prover, prove the case before the court of law.
But sir, I have a slide down here. Like you said that until unless any proceeds are generated from the schedule of it, you cannot take a charge. So until unless the A has not given the money to the authorities, there might not be any bribe. So after the authorities accepted, the money that is being given by the A will be the proceeds of crime.
Yes, certainly.
So why the A should be held liable? Because in one of the
bribe giving is also an offense. Huh? Bribe taking is an offense, but bribe giving is also an offense under Section 8 PCL.
But sir, actually, if we go that A should be held liable only under the schedule offense in the another court, not under the PMLA.
Now, what you are putting to me is a hypothetical situation. In hypothetical situation, if that case comes to me for an opinion with concrete facts, then we make a strategy that whom we want to make accused and whom we want to take a witness. But hypothetically, the answer is that both will become accused because bribe giving and bribe taking both is an offense. And even if he would not have parted with the money, even if he would have attempted to give the bribe, that is itself a commission of offense. Attempting to give a bribe is also an offense.
Sir, in one of the judgment movie case, this situation has arisen. So there the court actually stated that when this A person has an intention to give a money in form of bribe, he will prosecute it. But when he does not have an intention to give it in the form of bribe, he will not be prosecuted.
The judgment you are referring is via Balaji.
No, sir, it's Padman Kishore.
Yes. Via Balaji also this discussion has happened before the Supreme Court. But the court did not lay down any absolute rigid rule of law. It was just a simplistic discussion. And normally in those cases, we take call as per the facts of our case. The court was not particularly laid down any rule of law in that case that this should happen. The court was only simply discussing one of the proposition of law. And that proposition may apply in my case, that proposition may not apply in my case. Each case has to be decided by the facts of circumstances of that particular case. Now you are giving the hypothetical situation. In the hypothetical situation, both have to be already as an accused. And to prove my case, I may get one of them tender pardon to make an approval because both the accused will not be able to prove a case against themselves. Otherwise, we need independent evidence.
Thank you, sir.
Good afternoon, sir. So, my question is that recently the ED's issuance and subsequent withdrawal of summons, the senior lawyer Arvind Davner in the case of healthcare pro sparked upheaval in the legal community, and it was viewed as an attack on attorney-client privilege and judicial independence. How does the ED justify summoning advocates for rendering legal opinions? And what are the new checks and balances available in place to prevent the effects of investigation of legal counsel?
First of all, the matter is sub judice before the Honorable Court. The judgment has been reserved. Number one. Secondly, that very day a circular was issued by ED itself that no summon will be henceforth issued to any advocate without the permission of Worthy Director ED. So there have states, and after that transaction, none of the summon has gone to any lawyers. And we are still waiting for the judgment of the Apex Court. Next line of strategy will only be based upon the judgment of the Honorable Apex Court. Till then, no further summon will go.
Very good afternoon, sir. So recently, Honorable Justice Butcher had made a comment and he said that ED has registered around 5,000 ECIs in the past 5 years, but the conviction rate is less than 10%. So, sir, we would like to hear your practical aspect of this particular comment and why is this scenario happening?
We always hear that law is organic. You would have heard this term that law is organic, and PMLA is an evolving law. Most of the prosecution complaints which we have filed have been filed in the previous 3-4 years only. So it takes time for the agency to grow up. Now we are changing our prosecution strategy also. We are strengthening our legal wing also, so that there should be ample number of prosecutors available and the legal team is being strengthened. And certainly you will see a very improved result in near future to come.
Good afternoon, sir. My question is when the investigation of CBI is concerned and when they want to investigate in a state, they require the consent of a concerned state government.
Yes.
But when investigation by ED is concerned, no such consent is required. So many a times such allegations are put by especially those states where the government is of the opposition parties that ED is violating the principle of the federal structure, and so I wanted to ask.
The CBI jurisdiction emanates from Delhi Special Police Establishment Act. Our jurisdiction emanates from PMLA. In DSP, there is a specific restriction on jurisdiction of CBI that in a particular state, without the consent of the state, the CBI cannot investigate. But no such embargo has been placed upon ED in PMLA. Now we are investigating as per the statutory scheme, and whenever a case is filed against us, we justify before the court legally. Recently, 3-4 days back, I was going through a paper report, newspaper report, in which someone had challenged the constitutional validity of ED or legal validity of ED filing a supplementary complaint. So the Honorable Apex Court answered that if there is any problem in a particular case, you approach the High Court, the provision cannot be struck down. There is no problem with the provision. If there is some issue, you approach, you take the legal remedies. So when we are doing sensitive cases and high profile cases, there are bound to be allegations. But we cannot abdicate our statutory responsibility. We have to investigate.
Also, sir, I would like to request to repeat the names of cases which you gave for jurisdiction of
K. Rof Sharif and Rana Ayub.
Afternoon, sir. So at one point you said that ED either seizes the direct proceeds of crime or equivalent value of the proceeds of crime. So what happens in the cases where the primary accused no longer holds assets of the value equivalent to proceeds of crime? Are people who are recipients of the proceeds of crime or profit in from their perspective in a legitimate way, can they be deprived of that for the prosecution of the primary accused?
There are certain fundamental principles of law, and one of the fundamental principle of law is that if a person is getting hold of a property in good faith and for consideration and without knowledge of any offense, he cannot be deprived of the property. That principle is found legislative approval in PML also in section 8. If a person has legitimately acquired a property, his property will not be touched, but it should be in good faith without knowledge of the offense and for consideration. If in those cases he is not able to trace the direct proceeds of crime or value equivalent, on those cases we file prosecution complaint only only seeking from the court prosecution of the accused, not confiscation of the property. And if we are able to trace, then we seek confiscation of the property also. And in cases of successful prosecution, if we are able to get confiscation, after confiscation also the property either goes to the central government or to the victim. So when we are ourselves restituting the property to the victim, how can we take property of a person who is legitimately acquired? It is directly contrary to civil.
So in that case, if the purpose of the entire stage of offense and the occurrence of proceeds of crime was to satisfy, say, certain debts of a person, which he has done through this aspect, then doesn't the recovery aspect of PMLA become entirely?
But we cannot apply law in such a manner to do injustice. If we apply the law in the manner which you are hypothetically putting to me, then it will do more injustice than for. We are made to prevent the injustice, not to do injustice. One injustice cannot be cured by doing another injustice.
Yes, thank you.
Thank you. Yes.
Could you please elaborate upon how the ED starts its process of prosecution? So, how it receives, when you have elaborated, you have told us how it works, but could you please elaborate it? So, how?
Firstly, we register an ECIR. Then you can see, we register an ECIR, and on that basis, we decide whether we first want to go for a PO or we can. It is not so that we have to use our civil powers firstly or we have to use our criminal powers firstly. They can be used simultaneously also. Because we are summoning the witness, recording their statements, we are conducting search and seizure, we are arresting and we are issuing powers simultaneously. The civil and the criminal actions are overlapping. And from the beginning of filing of ECIR and the filing of prosecution complaint until the conviction order comes or acquittal comes, the proceeding will continue.
So there is no such complaint from which the complaint is received. How does it start the predicate offense is committed?
It depends upon what the case is and where the information we are getting from. It can be from foreign LEA also, it can be from Indian LEA also. We receive information under 54, we call for information under 54, and so moto also LEA send information to us.
Doesn't this make it problematic? Because as soon as the government says in Delhi, the whole opposition is in jail.
That question I cannot answer because we have not sent anyone till date. Which state we have sent the entire opposition behind us?
Most of the leaders are involved in some other scam.
That varies. If a person is accused or if a person has committed an offense, we are prosecuting or we are investigating on the basis of fact that the person has committed an offense. We are not saying that what position is also. We are investigating a citizen of India. We are not investigating a person who is holding a particular rank. When we see that criminal law is violated, we are following the statute. We are not going behind the person that he is so and so person, so we should arrest him or we should prosecute him. If some person has done an offense, that he will be charged. Law is safe for everyone. Rule of law says so.
Thank you so much. Good morning, sir. My question is particularly concerned with the section 9 of the PML. As you already stated that whatever property is confiscated by the ED is either sent back to the victim or it is placed in the central government as per the words of section 9. So as you have stated that it goes to the victim, under what provision the ED derives this power or under what provision ED sends the property back to the victim? Because the burden
The special court orders for the same. When the property is confiscated, then the special court orders to whom the property will go.
Because failing to this, then it would create a huge prejudice. For example, the money has been paid by the victim for the extortion or for that matter for kidnapping. That he is himself is a victim. But when he brings that property as a process of where that property is like that property consequently treated as a process of crime. So the victim and accused are treated as part. This is all I feel.
Before a property goes restitutes to a victim, he has to establish before the court his bona fides. Only when he is able to satisfy the court that about his bona fides, about his good faith and acquiring the property or having a proper interest in that property without any knowledge of the offense, the property will be restituted to others now.
Thank you, sir.
There are judicial safeguards to prevent this anomaly.
Sir, I have one more question regarding the ECIR. It is usually the topic of debate that ECIR doesn't disclose that in what capacity you are called for the investigation, whether as an accuser or whether as a witness. So, what's the reason behind this?
Because there are with the PMLA there are schedule and there are regulation. In the regulation, this mechanism is provided, and this has been upheld by the Allahabad High Court Division Bench also, the format of summoning.
At the last, my concluding question that we frequently come to hear that this law is draconian and sooner or later will be declared as unconstitutional by the Supreme Court of India. So, what's your take on it?
I don't think it will ever happen, because if that happens, it will be a huge loss to the country at large. In the beginning of the session, I told you that this law will be passed to satisfy India's international convention, and we will not be able to borrow money from IMF or World Bank if this law goes. There may be certain law may, like I told you, the beginning law is organic. There will be certain debates, some amendment may come, but that law will never go, because it is the international tested law. Other countries are also having the same law with certain exceptions.
Yes, sir. I agree with you. And in one case, the court has said that this law is a good piece of legislation which should not be misused. It should be only used against the shark, not the streams. Thank you, sir. Hello. Wonderful lecture, sir. I just have a question. It will take 1 minute. It has a background. It is not a hypothetical situation. During my internship with Senior Advocate Mr. Siddharth Gupta, a case came up that a person was not involved in any type of money laundering. He was a vendor. He took 3,000 rupees in exchange of cash from person X. He was involved in money laundering, and at last, what happened? The vendor's account was freezed. It requires, as you mentioned, it requires 60 days for the ED to conclude the investigation. But it took him 4 months to get his account increased. And during that 4 months, he was not able to pay his LIC premiums, he was not able to pay his rents. And his salary, he used to get some premium from other accounts that was also blocked. So, sir, during the proceeding, it was brought up by one of the senior advocates that it is easy for the ED to pick up the lowest hanging fruit, that are the common people. So, is it the same or why ED or any other investigating authority involved in such transactions?
In the beginning, when we begin with the investigation, the facts are hazy. We do not know who is actually involved and who is innocently part of the money. That is a matter of investigation. And only when we conclude the investigation, we come to know that yes, this person was innocent and money had just transferred to his account unknowingly, and this is the one through him. But the purpose of PMLA which gets frustrated if we don't attach or freeze the procedure plan. Only when we conclude the investigation and we record the 50 statements and we summon the person, we get to hear his side of the story. If we allow the POC to freely move, and that at the later stage we will not have anything, then what is the purpose of the investigation?
Sir, but the issue is throughout the process, the cyber offices, the cyber cell was involved. Dehradun cyber cell was involved in the process. They never replied to a single mail. They didn't even took 1 minute or 2 minutes out of their busy.
I understand what you are trying to put to me, but these are practical difficulties. These have to be taken care of on the case-to-case basis. There cannot be a straightforward formula for the same. This has to be addressed on a case-to-case basis. But for that, we cannot say that the investigation should not be done seamlessly. Certainly, I will put this point to my office that we should issue some circular on this aspect also, prior to rectifying it, when we get to prior to rectifying.
Thank you so much, sir.
Good afternoon, sir.
What's the one, sir?
Yeah. So, a few questions. So, as you like you said, the Enforcement Directorate makes headlines on a daily basis. So, what are and says the nature of the crime involved is time sensitive. You often mention that investigation process is often left incomplete.
No, I didn't say it is left incomplete. It is a daunting task to complete the investigation in 60 days.
Yes, sir. So, sir, the wide-ranging powers that are bestowed upon the Enforcement Directorate, what limitations or we can say a ceiling you would like to enact or we can say amend the existing payment provisions to instill confidence among the larger populace, unlike CBI or other investigating agencies?
There are checks and balances. We have having adjudicating authority, appellate tribunal, we are having courts, constitutional courts, and if whenever ED uses any of its power, we have to have material in our possession, and on the basis of material, we have to write reasons, record reasons to believe, and there has to be a live link between the material and the reasons to believe. These are sufficient checks and balances.
Thank you.
Good afternoon, sir. Sir, the ED has the power to selectively rely on evidence, but it is often argued that the ED selectively also excludes the exculpatory evidence which might favor the accused. So the principles of fair trial have to be upheld no matter what is the law. So are there any judicial checks or are there any safeguards for the accused against this selective discretion in the investigation?
Firstly, have you come across any particular case in which you have found this, or you are making a general assumption?
Sir, it can be reduced because, as you said, the investigation time is 60 days. The ED is so focused on dragging the accused to the court and the
I didn't say anything like that.
You said the time is 60 days.
At time 60 days, if we don't file within these 60 days, then maybe it may so happen that default may be granted to the accused. We try to conclude, and that is a good thing. That if you are trying to complete the investigation in a time-bound manner, that is good for the country also, for the judicial system also, for the accused also, that we are concluding the investigation in a time-bound manner. Where is the harm in that?
Sir, but in that case, specifically in PMLA, the accused also has reverse burden. There are many, the accused is heavily burdened.
But there are checks and balances. Now, first, for reverse burden to begin, we have to satisfy the foundational facts. Only when we satisfy the foundational facts, then will the reverse burden of proof begin. It is not that we will go to the court and we will say that the accused should explain. Firstly, we will satisfy what is the state of offense. Just by putting statements, we have to show the demonstrate the evidence before the court, both ocular as well as documentary. Only on being satisfied, the court will frame charges or take cognizance. Now there is a new concept of taking granting hearing at the stage of take cognizance itself, at the stage of cognizance itself. So how many more safeguards should be given to the accused? There is a hearing at the stage of cognizance, then there will be hearing at charge, then he will, if he faces the trial, then he will get to cross-examine all our witnesses. Sufficient safeguards are there in the law. How many more safeguards should be there?
Is there one more question? Does the accused have the right to access the statements or other things?
And during trial under 207, 208, we supply the entire material. And now, after seeing the inadequacy, deficiency, and many judgment, we are giving list of non-reliant document also. And if the accused files a 91 application and seeks some document of non-reliant, and the court feels that it is necessary, the court orders us, we give non-reliant also. What more can we do?
So you began the lecture by saying that how EC is hitting the headlines, but it is hitting the headlines for all the wrong reasons. With regard to the allegations, with regard with the political vendetta which is being carried out by the agency, you said that you are acting as per the statute and allegations are bound to be there. But sir, even the agency has a conviction rate of 0.1% since 2015, and even the CJ have to acknowledge that the political battles must be fought for the electorate and not by through the using the ED. And there have been innumerable instances where the Supreme Court had remanded the agency and the High Courts have done that. So, what do you have to say on that? I do not agree with your earlier response.
We are fully compliant with the statute. Whatever action we are taking in compliance with the statute. And if there is some anomaly on our part, the courts are routinely passing orders. So we are complying with the court orders also. Whatever investigation, inquiry, prosecution we are doing within the limits of the constitution, within the limits of the PML.
Sir, if that was the case, the conviction rate would have not been 0.
I always we answered this question when someone was asked that we are strengthening our prosecution, we are strengthening our legal team, and the number of cases that have been filed, volume of cases that have been filed in the recent time only. It will take some time for the fruits to come. But certainly in the near future, we will see improved results.
Is it only strengthening just to harm political leaders to the opposition party, or any unknown factors still satisfied that you are going to that you are acting as per the statute? Because time and again, in innumerable instances, the courts have written prepared confronting the agency, and the agency is not, I mean, bothering as per those statements.
On what basis you are saying that agency is not bothering? How do you know we are not changing?
Because time and again, Supreme Court have to take because
we are following the judgments of the court in all the cases. Whatever directives are coming from the court, we are following the rule of law. Whatever the court is asking us to do, we are doing it. And if you have not satisfied or agreed, we challenge it to have a higher forum.
Sir, I had doubt that in case the Madras High Court has recently stated that if the schedule offence has been dismissed on certain technical grounds, so then also the PML proceedings will continue. But if we see the Vijay Mandalal case, where it is said that if the schedule offence has been in the schedule offence, the person is acquitted or something has been done where the schedule offence has been dismissed, then the proceedings of crime or no proceedings will take place under PMLA. So whether the judgment of the Madras High Court gives more power to the ED to continue the proceedings under the PMLA.
Madras High Court passed the judgment in the particular facts and circumstances of the case. Vijay Mandalal is a proposition on the facts which were portrayed before the court in that case. Because I have told you in the beginning also that law is organic. So when the proposition comes before the court and if the court feels that yes, this point was not addressed during Vijay Mandalal, the High Court is not powerless that it cannot give a pass judgment in its own case. So when the question came before the Madras High Court, the courts had seen the facts and circumstances and said that if this is allowed, this will be travesty of justice. So in that particular case, the court said that if technical grounds are taken to defeat PMLA, that cannot be counted. So the court allows that PMLA should ED should challenge that schedule of offence.
So, sir, can we see that the need has arisen where we have to actually define that what are the technical grounds on which the schedule offence has been dismissed, and also the
we are in the process of the same. We are in the process that as a department also and the courts also. I told you in the beginning itself that this is an organic law. Every day, every week, we are getting new judgments. So we are also trying to comply with all the judgments which are coming. And this law is evolving on a day-to-day basis because the prosecution are increasing under this law. So the law will take its time to settle down. We should have some long-term patience and slowly the law will get settled. It is an organic process. We cannot hasten it or fasten it. It will take time.
And sir, last time, now the recently the Vijay Mandalal case has been filed for the review before the Supreme Court. So whether do you think that certain changes will take place related to this also, that it will be transferred and other related to the bail?
Now that is the matter which is sub judice. I cannot comment on sub judice matter. That is for the court to see.
But whether these issues will be raised because they are diverging where the High Court and the Supreme Court.
The issue is that I cannot answer on sub judice matter. No? I cannot tell about what will be the strategy in a sub judice matter.
Thank you, sir.
Direct news is not available, then we offer value the value attachment.
Yes, in a scenario, if the person is collected money at the time, and only after there is state of that, only how much cases, how much currency notes are available there. So in that case, also the value of that much amount that he had.
Direct news is not available, we will have to go for value the attachment.
So my further question is that because the aim of this option, strategy is to prevent the money laundering. Now the money is not in the position to be further laundered. So why are we going for the value? Because in the earlier case when you mentioned that it is paid for the tax of use. So in that case, that person has used that property.
That situation is not envisaged by the law. situation you can go for value jump. Wherever direct use is not available, the law says that you can go for value attachment. Yes, it does not say how or why the direct use is not available. If it is available, go for it. If it is not available, go for value jump. So the second scenario, we can go for the value part. Yes. My second question is regarding the Mayank element in section B. Yes. You have mentioned that either it is knowingly party or knowingly involved, but all of the words that use word or knowingly party or knowingly indulge or actually indulge or actually part of the offense. So by this interpretation, can I say that Mayank is not an essential element? Because they use that if Mayank is taken out of the PML, drastic consequences are followed. So PML is a strict, it's not a strict level. Knowingly knowledge is required. Though knowledge we prove during trial. The concept of knowledge as per the limit of Prabhu Parantriya, we have to prove during trial. But we have to. If we remove the knowledge element, it will be very arbitrary. Because there are certain offenses in which the limit of measure is not required. I clarified that PML is not a strict liability offense. So if a strict interpretation can be done, then it can't be. It says that measure is not required. If you give some practical example, then you will yourself say without knowledge in that thing. Supposedly, a public servant takes rupees 10 as a bribe, and he drinks a tea, and he pays that rupees 10 to the tea vendor. Then the tea vendor will be in possession of POC. Then the tea vendor will also become an accused. If the knowledge element is removed, then the consequences will be very different. So the knowledge of possession is necessary knowledge of proceeds of crime, and that money is proceeds of crime. When it's happened, that is. No issues. Shall we conclude the session then? Thank you for being such a wonderful audience.
If anyone from the audience has any more questions, then we'll post a Google form. You can upload your questions. I now invite Naman Sharma to deliver the vote of thanks.
On behalf of Maharashtra National Law University, Nagpur, we extend our profound gratitude to you, sir, for delivering today's lecture. This afternoon, we have not merely been in the presence of a speaker, but of a man who has lived, fought, and excelled in the very word he spoke about. Your talk reminded us that while money may often take a circular route in laundering, the path of justice, though long, must always be straight. And of course, we now fully understand that layering is not just a fashion term, and placement is not just about getting campus jobs. Sir, from today's lecture, we have learned that the ED's idea of a conversation in a money laundering case is very different from what we saw in a Vijay Mallya podcast. The accused don't get soft questions and a smiling ghost. They get fact checked, figures traced, and every answer tested twice. Once again, thank you for your precious time, your stories from the field, and your generosity in sharing your knowledge and wisdom. We hope this is not the last time we have the privilege of hearing from you, sir. Perhaps next time we will have to introduce you even with even more impressive titles, maybe even as a respected member of our bench. We would also like to place on record our sincere gratitude to our Honorable Vice Chancellor, sir, Professor Dr. Vijendra Kumar, sir, for his constant guidance, encouragement, and support for making possible this today's lecture. We extend our sincere gratitude to respected Shri Deepak Bhagwat, sir, Registrar of the University, for readily approving this lecture on such a short notice. We are also deeply grateful to respected Shri Rahul Naveen, sir, Director of the Enforcement Directorate, for kindly permitting Makhija, sir, to deliver this lecture, and that too on a working day. We place on record our appreciation to the administration, faculty advisors of the center, the faculty members, our dedicated non-teaching staff, IT staff, the members of the center, the photography club, the students, and to every individual who in any measure contributed to the success of today's program. On behalf of everyone present, I thank you once again and wish you all a very happy Independence Day in advance. Jai Hind.